But let's turn to the business at hand. Today's author spotlight was Scott Hempling. He's a well-known attorney on regulatory issues. He's represented many, many states, private utilities, consumer organizations, and he is a scholar. He has taught at Georgetown University. He's taught on the side. He's led, was the intellectual leader at NRRI for a number of years. And we're just so pleased to have him be presenting his new second edition of his book, Public Utility Performance, the Law of Market Structure, Pricing, and Jurisdiction. So with that, Scott, and the format that we're going to follow is a little bit different than what we followed in past book talks. Scott and I are going to have a little bit of give and take at the beginning, and then Scott's going to dive into the various chapters of the book. Scott, do you want to give a few introductory?
Well, briefly, Carl, thank you for the great work that you and the commissioners and the NRI and NARIC staff are doing for our country. There's nothing more important to life, to the future, and then to bring discipline to the performance of the companies that provide us with these essential services. So the work that you do and your staff does and the commissioners do every day is very inspiring, and I'm honored to be a part of this community. I'll say only one thing before your first question, Carl. As an employee of the U.S. government, an employee of the Federal Energy Regulatory Commission, I can speak only for myself. So what I say today, which I hope will be objective, cannot be attributed to the commission, the commissioners, my Office of Administrative Law Judges, any staff person other than myself. And with that, Carl, I look forward to our dialogue. Please start.
Thank you very much. Judge Hempling, and it's such a pleasure to call you that. Public utility law comes from legislative activity, laws, commissions, and courts from all 50 states and multiple federal agencies. Thousands of legal decisions actually over dozens of years. How do you organize all this material? What's your fundamental way that you've organized your thoughts in terms of laying out a treatise like this on regulatory law?
Well, Carl, as you point out, the sources of regulatory law are multiple. We've got legislative decisions at the federal and state level. We have agency decisions at the federal and state level. We have court decisions at the federal and state level. These decisions arise under constitutional law, under antitrust law, under contract law, under tort law, and of course, under the substantive utility statutes that Congress and the 50 state legislatures have passed. So it's a polyglot of sources, and not all of them are consistent. The logic of the book is to organize them into three major categories in this order. The first is market structure. Market structure is who's buying and selling, and what are they buying and selling? What is the appropriate mix of monopoly markets and competitive markets? How do we go about converting historically monopolistic markets into competitive markets? And because authorizing competition doesn't guarantee effective competition, how do we prevent situations where a small number of sellers, especially the incumbents, can dominate the markets and act anti-competitively and inconsistently with the vision that we have for performance? So I start with market structure. By the way, in the old days, when people lectured on regulation, they started with cost-based pricing. Why? Because all we had were monopolies, and the way that monopolies charge is through cost-based pricing. So we never talked about market structure until the last 30 or 40 years, and most significantly over the last 10 years. So I start by describing the legal issues associated with market structure. That's the part one of the book. Then it turns to pricing. We have people in the market, they're buying and selling. What are the terms and conditions under which these transactions occur? What are the statutory and constitutional standards that apply? Why do we take law as the foundation that ensures that sellers are fairly compensated and customers are not exploited. And we talk in the book not just about pricing, but as we'll discuss when I get into detail, there are certain doctrines associated with terms and conditions that bring transparency and predictability to the transactions that we depend on. So part one is market structure, part two is pricing. Then I turn to federal state jurisdiction, because most utility services today are produced and consumed in what on the surface appear to be intrastate markets, but in reality are interstate markets. We have a governmental structure that was designed in the 1780s, a federal level and a state level. We have the primary federal regulatory statutes that were enacted in the 1930s. Here we are in the 2020s. And so we have questions about how do and how should federal and state policymakers interact when regulating the same providers and the same transactions. So that's what the book covers. It covers those three topics of market structure, pricing, and federal state jurisdiction. Now, anybody who hasn't been underground for the last 40 years knows that there's a fourth area, and that's corporate structure, mergers, and acquisitions. I don't cover that in the book, and I'll tell you briefly why. When I prepared the 2013 edition and sent the draft to the publishers at the American Bar Association, they wrote back within moments, "You promised a 500-page draft. This one is 750 pages. Fix it." So I took out the entire set of chapters on corporate structure, mergers, and acquisitions so that we could meet the 500-page limit. That turned out to be a blessing in disguise, because if anybody remembers from last year, I was able, somewhere between roughly 2015 and 2019, to write a separate book on the problems associated with structure of corporations, mergers, and acquisitions. That one is an opinionated book, whereas I aim to make the current book an objective book. So there's a whole separate book on that subject. I don't want people to think that the law of public utilities excludes issues of corporate structure, mergers, and acquisitions. So, Carl, that's my answer to your first question. Thank you.
Well, thank you, Judge. Many regulatory professionals focus on one particular area. I, for example, specialize in electricity, others in gas and in water, telecom, or transportation. How have you addressed all the different, or do you address all of these different regulated industries in the book? And is it by bringing together sort of common legal themes and things of that sort?
Yeah. Well, Carl, first of all, if you call me Judge one more time, I'm going to start calling you Dr. Peckman. So let me have at least
my older brother would object to that. Okay. The medical.
Yeah. At least let there be at least one place I can go where I can just be good old Scotty Waddy Doodah. So
okay, I don't know if I could say that 3 times fast. Go ahead.
It's an interesting question. See, I grew up in the electric industry. I got out of law school in 1984, and I've been basically talking electricity all that time. And that's the case with most regulatory professionals. They're focused on their own area. It's actually because my time at NRRI, when I was the director between 2006 and 2011, that I realized, having dealt then with trucking, rail, gas, telecommunications, water, in addition to electricity, when I finally learned to become, I would say, semi-literate, not fluent, not even literate, semi-literate in these other areas, that I realized the commonality of the legal principles among these industries. And when I realized that for people to have the most influential, richest, most contributory careers, for people to become commissioners who have to deal with all of these subjects at once, it was important to see whether the law that I had learned as an electricity lawyer would apply to the other areas. And it turns out it does. But when you think about it, all utility law, regardless of industry or era, has shared 6 characteristics. The first characteristic is its mission. The mission of law in the utility field is to align private behavior with the public interest. The second shared characteristic is the flexibility of this law. It accommodates multiple market structures, from monopoly to competition, and multiple public purposes, cleaning up the environment, helping make service affordable, protecting privacy. The third shared characteristic is how law integrates the multiple professions of regulation: accounting, economics, engineering, finance, management, even politics. The fourth shared characteristic is the expansiveness of utility law. It ranges from state grants of exclusive franchise to federal constitutional protection of shareholder investment. The fifth common characteristic, as we mentioned, is the set of sources. Law comes from state and federal constitutions, from statutes, from agency rules and orders, from judicial opinions. And lastly, what's shared among these industries and deeply embedded into law are procedures: the legislative procedure, the rulemaking procedure, the adjudicative procedure, the enforcement procedures, and then, of course, judicial review. So it turns out that the principles that the book describes are applicable to all these regulated industries. I want to be very clear and say that this book is not a substitute for a specific textbook on electricity law or on telecommunications law or on water law or on gas law, but it does have the legal principles that you can apply regardless of the industry that you practice in, Carl.
Okay, terrific. Well, Scott, or was Scotty Wadi Duda? Thank you for that. But it's one of the things that I found really interesting about the book is that you explain how the Interstate Commerce Act of 1887 really is the genesis of all regulatory law, or of regulatory law. And why is that still relevant today? I mean, that's 150 years, just about 150 years ago.
It's a great question. So correct, the Interstate Commerce Act of 1887 was passed because of the public's anger at railroads. Railroads controlled so much of the economy and then so much of the nation's politics. And so the grandparent of all public utility law in the United States is the Interstate Commerce Act of 1887. But the book also points out that most of the legal principles date back to the Middle Ages. Somebody would control the turnpike. Somebody would have the only horse and carriage in town. And the king, or whoever the king's delegate was, would be pressed by the citizenry to find that prices were unjust, unreasonable, discriminatory, granting undue preferences. And those medieval concerns have been replicated in the Interstate Commerce Act and in just about every federal and state regulatory statute I've ever seen. So why does all this still matter today? Variety of reasons. When you think about the key phrases in regulatory statutes, that rates, terms, and conditions shall be just and reasonable and grant no undue preference or advantage. Why are those principles relevant today? Let's just take a couple of current concerns. Climate change. So we're asking questions like, should we make utilities and their customers responsible for greening production and reducing consumption? We have to look at the phrases just and reasonable, not unduly discriminatory, as the legal source for confronting that question. What about when we debate the digital divide and we ask questions like, should we bring broadband to every home, and at what cost, and at whose cost? We're going to ask questions about, what is the obligation to serve? What is universal access? If universal access requires extra funds to bring broadband to rural areas, Are we all beneficiaries such that we should all bear those costs? Or should we put those costs solely on the rural areas? Privacy. We'll become concerned about privacy because everybody's usage data is now a commodity in the hands of those who can profit from it. And we ask questions like, should consumers' private consumption data be available to profit seekers? By the way, that reminds me of that fine study that Dr. Sherry Lichtenberg, did back when I worked with her in the around 2010, 2011. You want to understand the foundation for studying that question about privacy and smart grid in particular. Go find her study on that topic. So the questions like that, climate change, digital divide, privacy, what do these questions expose? Well, first, they expose ideological tensions, such as, well, for our regulated services, do we want private ownership or public ownership? Do we want government protected monopolies? Do we want unregulated competition? Do we want some kind of mixed markets? In fact, one of my law students, she's a graduate student, she's from Saudi Arabia, and her paper is on the privatization, pros and cons of the airports in Saudi Arabia. And, when she brought that topic to me, I realized how flexible the legal principles that I teach in class and in this book are used. I'll tell you another paper that somebody in my class is writing, space travel. Okay, so you're Elon Musk or you're Jeff Bezos. And there's a concern that the new suppliers of space travel are insufficiently motivated to protect against cyber attack. Well, that's a question for regulatory thinkers. Do we have a situation like a street in a neighborhood with no signs saying, slow down, children live here, requiring regulation? Do we have a situation in space travel where we have a market failure justifying regulatory intervention? Well, but you can see immediately the ideological tensions. Private versus public, government protected versus unregulated, who bears what costs if things go wrong. And the other tension that these questions such as climate change, digital divide, and privacy expose is the tension between federal and state decision makers. I am sure glad to hear that there will be a federal state panel talking about transmission, because there are in-state concerns and there are multi-state concerns. We all are residents of the United States of America. We all depend on a national economy. We also breathe the air that's local and travel the streets that are local. So working out a way to resolve the inevitable tensions that happen in a mixed economy, in a democracy, with congestion, with dense populated areas, with sparsely populated areas, deciding in law how to allocate decision-making authority among the states and between the federal government and the states, a struggle we've been dealing with for, well, since the 1930s, time to get it right in these industries. And so we ask questions like, what aspects of utility service are national, warranting uniform regulation and minimum standards, and which are local, allowing for state experimentation? These questions, as old as the country itself, remain with us today. And what I've also realized as I observe the excellence in the regulatory community is how all of these challenges are forcing us to rethink our decisions. So let me give you 5 quick examples, Carl. First, the decision about whether to inject competition in a particular service market. So if you recall, in the 1980s and 1990s, policymakers who were struggling to inject competition into historically monopolistic markets, they had really one major tool, and that was to require incumbents to unbundle competitive services from monopoly services and also provide non-discriminatory access to the monopoly services. We had that in electricity generation and transmission, in gas wholesale sales and pipeline transportation, in telecommunications, access to the central exchange, at the same time that there would be a competition for local telephone service, and for long distance. And central to those solutions were always the incumbents. But today, the regulators are sometimes inviting new entrants to displace incumbents, to have what we call franchise competition, or what others call not competition within a market, but competition for the market. And so FERC has initiated back in the Order 1000, the possibility of competition to build new transmission facilities. So a transmission facility itself could be a natural monopoly service, but there could be competition for the opportunity to provide that service. One of my students is writing a paper on the possibilities for competition to offer storage as an alternative to transmission, and also competition to provide distributed energy resources as an alternative to new distribution systems. So that first example of how we're rethinking how we do business is this concept of injecting competition. Well, secondly, there's improving competition. Anybody who's tried to master a musical instrument knows that it demands continuous work, and making competition work demands continuous work. So people will recall back to Order 888, 1996, 25 years ago, when FERC decided to direct incumbent transmission owners to provide non-discriminatory access. And during that same era, in the late 90s, early aughts, some states, 15, I think, introduced retail competition for electricity and gas. Congress has made competition realistic for local and long distance telephone service. But just about everybody agrees that in these potentially competitive markets, we still have suboptimalities. And so FERC and the states are fiddling with this and adjusting and improving. FERC has been ordering regional transmission organizations to allow wholesale market entry by providers of non-conventional services. Services like demand response, storage, frequency regulation, variable energy resources. States, I remember reading about New York, announcing new licensing requirements for sellers of retail electricity and gas so that customers are getting more than just commodity service. The Federal Communications Commission has on multiple occasions struggled with net neutrality and whether content creators should also control access to the bottleneck internet facilities. So improving competition is a second area that is at the frontier of applying these principles. The third one is stranded investment. So thinking back to the 80s and 90s, the stranded investment debates, which involve the Constitution's takings clause. The government cannot take private property without just compensation. And when a utility volunteers to become that utility, it subjects itself to government mandates, like the obligation to serve. And it subjects itself to government mandates to spend millions and billions of dollars to build the infrastructure to carry out that obligation to serve. But then government gets the bright idea to introduce competition. So all of a sudden there's a mismatch between that government imposed obligation to serve and the customer's opportunity to shop. And that mismatch is what stimulated the stranded investment debates in the 80s and 90s, which involved natural gas pipeline capacity, gas take or pay obligations, nuclear generating facilities. The modern analogs are what? Decarbonization. If we're going to shut down this coal plant before the end of its useful life, somebody's got to pick up the unrecovered costs. If we're going to replace the old analog one-way meters with digital two-way meters, somebody's going to have to pick up the unrecovered cost. That's the modern stranded investment debate today. We can't ignore it. The same legal principles are going to apply. The fourth area I'll mention in this section of our conversation is quality of service. When you have shortfalls in quality of service, you can get tragic effects. We had a gas pipeline explosion, San Bruno, about 10 years ago. Neighborhoods destroyed, lives lost. There was a gas pipeline explosion up in Massachusetts involving Columbia Gas a few years ago. Now, traditionally, we've had penalties, new mandates. What are the quality of service challenges today? Cybersecurity, storm hardening, distribution line undergrounding, wildfire planning, quality of service rules, and innovation. Normally, quality of service was about keeping the lights on, but today regulators are realizing that quality of service involves innovation too. Just read the New York Commission's irritated order about retail electric service providers and how the so-called improvements to service have been nothing more than swag. New York Commission wants to see real quality of service improvements. And lastly, I've already alluded to, this fifth frontier area is clarifying the federal state jurisdictional relations. You know, for lawyers, it's been a dream because the grinding of the gears between what states want to do and what the federal statutes authorize have produced an unusually large number of Supreme Court cases and appellate court decisions that interpret and apply the federal state boundaries that Congress created over 80 years ago. Again, congratulations to those who are going to participate in this transmission panel. Carl, with that, we can turn to the next question or any questions you might have gotten from the listeners.
Actually, we do have a couple of questions, and I think I'll ask those questions as we're going along, just because I think they're quite good. And in fact, while you were talking, something that you said struck a chord with me with respect to the Market Street Railroad case, and we have a question about that, which is, what is the current relevance of the Market Street Railroad case to Stratton investment issues? So,
how an interesting question. So, for those of you, I hope not too many, who are unfamiliar with this landmark case, Market Street Railway is about obsolescence. And the question that arose as horses and buggies got replaced by streetcars, which got replaced by trams, and eventually the good old American automobile, a utility, a streetcar utility, asked for a rate increase. And it said, well, we're losing passengers, so we have to spread our fixed costs among a smaller number, so we're going to have to raise our rates. And the commission said, well, how smart is that? This is a dying industry. You raise your rates, you're going to lose even more passengers. So the commission didn't set the entire rate increase. It left the company with a return on equity that was quite small, assuming it had any customers that would come, roughly around 6%, which is a lot lower than what you normally need to attract investment, even to a low risk business. And the company said, you're mandating an obligation to serve and not justly compensating us. You're violating the Fifth Amendment to the Constitution. And the Supreme Court made utterly clear in reasoning that it has repeated several times since then, that it is not the job of regulation and it is not the job of the Constitution to protect a dying industry. So the relevance today, I want to state this very carefully because I don't want people to run to their phones one way or the other and say that there's no constitutional protection anymore and everything's up for grabs. But let me be very clear about this. What the case signals, and I would say it's progeny, Duquesne versus Barish, 1989, what these two cases signal is that there is no constitutional assurance of financial survival for a public utility, that a regulatory system can place on the utility the business risk associated with technological change causing obsolescence. That's what the case stands for, that there is no automatic constitutional protection. Is there constitutional protection? Sure there is. The government has to live by the expectations it creates. If the government creates an expectation legitimately held by shareholders that when they make an investment, they'll get the money back from the customers, the government has to honor that. Now, that part is not in Market Street Railway and it's not in Duquesne, but it's clear in other cases. So that's my answer to your question. The one footnote I'll add to that, and it's not a footnote, it's a warning in a final paragraph in Duquesne and Barish is that the court will be worried and will entertain constitutional attacks if regulators start switching back and forth. Heads I win, tails you lose, and treat shareholders that way. But bottom line is, stranded investment policy remains fundamentally a statutory policy with regulatory discretion bounded by the Constitution's requirement that if you create an expectation, you have to honor it. But if you don't create that expectation, company could be at risk. Carl?
Okay, well, thank you. I've been thinking about Market Street a fair amount recently, but that's a conversation for a different day. Can you, let me just ask you one other question that we have in our question box, and then I'm going to ask you to sort of address the different chapters and what you've covered in the book. Can you discuss codes of conduct, utility codes of conduct, and the foundation for commissions to require them for ensuring fair competition with developers of distributed energy resources? What prevents utilities from seeking state legislation to preclude adoption of such codes and thus preserve the monopoly? And of course, I think there's an adjunct question to that, which is the decision of what utilities are allowed to participate in versus not participate in. Certain states have restricted, for example, utilities from owning generation within their service territories. Scott?
Yeah, excellent question. Excellent example of how decades-old principles apply today. So what the questioner is describing is an example that appears frequently, and that is that we had historically a monopoly providing a bundled service. You get electricity in your home to heat your appliances, and to bring it there, there's generation, transmission, and distribution, all provided by a single company. And then somebody realizes there can be alternative providers to one or more of those stages. And might it be good to use competition as the way to select those providers? And might it be good for customers to have choices? And if I'm the CEO of a historically monopolistic utility, I'm saying, darn, that'd be a cool thing for me to get involved in. And I've got a lot of advantages. I've got a reputation. I own the customer data. I control the bottleneck. I'll be everybody's first choice because I'm the one that keeps the lights on every day. And the response to that is, now, wait a minute. I thought we wanted to get some fresh thinking, some fresh blood, some new companies, some competitive accountability in this area. And so the question always arises when you have a company that is historically the monopolist and which controls monopoly facilities. First, should it be allowed to get involved in a competitive market in its own area? And second of all, if it is going to get into that business, how do we prevent both anti-competitive conduct and unearned advantage? And those two things are different. Anti-competitive conduct and unearned advantage. And that's why we have codes of conduct. Now, I don't want to give a half-hour lecture on this, so let me get to the point very quickly. Codes of conduct, as the questioner knows, aim to prevent an anti-competitive conduct in the sense of the incumbent using its monopoly facility to discriminate against its competitors. Anti-competitive conduct. I've also been concerned about what I call unearned advantage. Just to take reputation. There's no anti-competitive conduct associated with working off your reputation. I ran a law practice for almost 30 years, running it on my reputation. Yeah, I had an advantage over people that were getting out of law school for the first time. It's going to take them years to catch up with me. And some of my students are going to catch up faster than I realized. So I'm feeling the heat behind my back. Why do you think I took a judge's job now? So that's why we have codes of conduct. But here's the point. Codes of conduct are statutory. I mean, ultimately, they're statutory and then applied by the commission through its own orders and rules. But the statutory basis is rates have to be just and reasonable. So don't recover your don't recover your competitive costs from your monopoly customers. And there shall be no undue preference or advantage. So don't give yourself advantages in the use of your monopoly transmission and distribution facilities and stiff your competitors. Anti-competitive conduct is excluding competitors or raising your rivals' costs. But it's statutory. There's no constitutional protection of fair competition. There's no constitutional protection of customers. Customers don't invest in the business. They don't put private property into the business. They buy service. So there's no constitutional protection. And First Amendment, democracy, utility is perfectly free to go to a legislature and say, give me all the advantages that I can't earn through the merits so I can keep competitors out of my backyard. So it becomes a political issue, Carl.
Yeah, well, I'd love to get into the state action doctrine at this point, but I think that the next question for you is just sort of the one where I ask you, could you run through, give us an overview of what you cover in your book?
Yeah, that would be great.
Before you do that, let me just indicate, I think that people will understand from your answers just how thoughtful you are with respect to all, and it's really tremendous. And when you were talking about unbundling the other night when I was reading the book, I read your definition of unbundling. I said, that's the clearest definition I've seen. So I just want to reiterate how terrific a book it is. And I'd love to hear your overview of the whole book now.
Yeah, thanks, Carl. So would you confirm, Carl, you can see on the screen this diagram?
I can see it.
Yeah, and by the way, NRRI has this diagram, and I'm sure that on request, they'll be glad to send it out. So I tortured an assistant of mine many years ago, back when I first wrote the first edition, to diagram the entire book and its chapters. And I'll use this diagram, and I won't make you look through every single page of it, but let me sort of describe how things are structured here. I recognize the print is small, so when I get to some of the later pages, the view will improve. Anyway, you can see that here are the major areas: market structure, from monopolies to competition, who can sell what to whom, and then pricing, how much can sellers charge and who decides, and lastly, jurisdiction, state, federal, and future. Now, first, I thought it useful. I asked my law students in a first class, what is law? And these are second and third year students, so they should know by now, just if they have to look at the bill that they get from the school in terms of tuition they're paying. But what is law? Law establishes, well, it has purposes, right? And to achieve those purposes, it provides or allocates or creates power, rights, and responsibilities, right? Law is to achieve a purpose, and it does so by acting on the actions of actors. Regulatory law involves power, rights, and responsibilities to achieve a purpose. And so the very first chapter, I simply talk about, well, the purposes of regulation. Well, this is what a speed limit is. Again, is to align the private behavior with the public interest. The public interest is in not too many deaths on the highway, right? If the public interest was in no deaths on the highway, there would be a speed limit of 10 miles an hour on the Beltway. But the public interest is not too many deaths on the highway. The public interest in utility law is usually rates, terms, and conditions that are just and reasonable, reliable service, sufficient infrastructure, affordable rates, consistency with environmental values, values of privacy. Those are political decisions that establish the purposes, and then regulatory law carries them out. Turning to market structure, I have 4 chapters. The first chapter is to understand the traditional utility monopoly. Now, there we reach back nearly 100 years to find out that the traditional utility monopoly has various dimensions. It has an exclusive franchise. It has an obligation to serve. It consents to regulation. It has quality of service standards. It has the power of eminent domain. And by the way, in at least 45 states, even if it's negligent, you can't sue it. Understand the traditional utility monopoly, not because it's ancient history, because still in water, gas distribution, electric distribution, some parts of the telecommunications system, we still regulate traditional utility monopolies. Now, the next stage is authorizing competition. It's that legal action that we've been accomplishing in telecom, gas, and electricity over the last 40 years. To authorize competition, we have to eliminate the legal monopoly at retail. By the way, constitutional questions arise, as I've described, in terms of stranded investment. Shareholders had the expectation that they would have monopolies over service territory. Now you're taking that monopoly away, the value of the company goes down. How legitimate was the expectation that they should have a monopoly in perpetuity? And with respect to the facilities whose costs still have to be recovered, what was their expectation? So authorizing competition has those elements. You know, I never used the word deregulation. Besides its political baggage, it's imprecise. It's almost a misnomer, because as you can see, the act of bringing competition to a historically monopolistic business involves a heck of a lot of regulation. So we authorize competition by eliminating the legal protections of the traditional utility monopoly. But authorizing competition does not make competition effective. When we talk about effective competition, and that's the adjective that economists use, effective competition. Not monopolistic competition, not oligopolistic competition, not half-baked competition, not immature competition, not aspirational competition, but effective competition. And so this chapter defines the goals of competition. It can be lower prices, it can be more reliability, it can be higher quality of service, it can be more innovation. There are all sorts of goals you can have with effective competition. If you're an ideologue, you just say, I want more competition. But if you're a policymaker, you have a vision, you have a purpose, you have a set of metrics by which you're going to judge your decisions. And so the steps, as Carl just pointed out, involve unbundling the incumbent's monopoly services from its competitive services. Unbundling in a sentence means make available for sale separately what had been mandatorily combined for sale before. Remember, I talked about the distinction between anti-competitive conduct and unearned advantage. If you want competition on the merits, eliminating anti-competitive conduct is necessary, but it is not sufficient, because the incumbent is likely to have what I call non-facility entry barriers. Its reputation, its control of the data, its knowledge of the service territory. Or you can say all those things were earned by sweat and shoe leather, but the fact is captive ratepayers paid for all that learning. And if a competitor has to replicate all that learning with its own money, unable to charge captive ratepayers for it, we have a competition that is not on the merits because it's been distorted by unearned advantage. So those are the legal topics that are covered under this chapter. Now, I was taught this early in my career by one of my wonderful mentors, David Penn, up in Wisconsin. And he told me, you know, Scott, every competitor aspires to be a monopolist, right? And I don't hang a sign in my front yard saying my wife is available. We're all interested in retaining what we control. And so it's not enough to authorize competition. It's not enough to initially make competition effective. We have to monitor competition for anti-competitive behavior. So the book talks about the various forms, tying, price squeeze, predatory pricing. By the way, I put market manipulation in this chapter, and I realized dealing with my students a couple of weeks ago that market manipulation is not anti-competitive behavior. It's not trying to destroy a competitor. It's trying to get an unearned advantage. So I probably need next time around, Lord help me if I write another edition, to retitle this Monitoring Competition for Conduct that Undermines Effective Competition, because manipulation itself is not anti-competitive, it's anti-market. Well, briefly then, because I know we're getting toward the top of the hour, And we did promise, well, we gave ourselves 90 minutes, but we won't need to take the whole amount. Here's what we did in the book on pricing. How much can sellers charge? Who decides? Well, there are, let's see, 5 chapters here. First 2 chapters deal with the 2 types of pricing that we have in law today. The pricing that so many of you do all the time, just and reasonable prices in non-competitive markets. These are cost-based rates set by the seller. So the book explains the rate-setting equations, what we actually mean by just and reasonable, which is not just a customer-oriented provision, it's a producer-oriented provision. We want production. We want sufficient supply to meet demand. We have to set rates to attract investors. We don't just protect consumers. And so we don't want costs to go into rates if they are imprudent or reflect inaction that's imprudent. And so we ask the question, who should bear the cost of inefficiency and waste? But then there's this extremely important question that's raised by the Market Street Railway case and the Duquesne and Barish case, which is, what if a utility just has rotten luck? It acts prudently, but the outcome is uneconomic. Maybe it was smart to build that coal plant 30 years ago. Now it doesn't look so smart. It's not so economic. Who bears the risk of that rotten luck? Again, the Constitution doesn't speak to that question except to leave it up to regulators unless they've created some promise. So the book talks about those concepts, just and reasonable prices in non-competitive markets. Then, especially at FERC, we have a situation where we have a regulatory role in pricing, even in markets that we've deemed competitive. So what happens in chapter 7 of the book and what happens at FERC, and I'm just being objective here, is that FERC receives applications from wholesale generation sellers, applications where the seller says, I want to charge whatever I want. I don't want somebody looking at my costs. I want somebody limiting my profits. What do they care? As long as my prices are disciplined by the forces of effective competition, as long as I have no market power, the ability to raise my prices above competitive levels and keep them at that high level without losing sales and profit, as long as I have no market power, why can't I just price whatever I want? Well, the courts have said that the just and reasonable standard that exists in the Federal Power Act and the Natural Gas Act does allow a situation where FERC frees sellers to charge any price they want under 2 conditions. The first is that FERC has to screen these sellers to ensure they lack market power. And FERC over time has to monitor these prices and these sellers' conduct to make sure that the market power that they didn't have, they somehow acquire. So we have a chapter on each of these 2 pricing mechanisms, but then come the doctrines. And these are the doctrines that at least 3 of which all of you are so familiar with. The doctrine of discrimination. Well, it's a prohibition on undue discrimination. And so the chapter distinguishes due discrimination from undue discrimination. At bottom, it's about allocating costs to the people who cause those costs. And as long as you're allocating costs to the cost causers and allocating them to the benefit receivers, you are okay under due discrimination. This business is about transmission. I mean, we have fights over whether it should be built, and then we have fights over if it's going to be built, who bears what costs, who are the beneficiaries, who is causing the demand that necessitates the new construction, and is there a lower cost way? Well, that's a prudence question. Can we use storage instead of transmission? But once we have the transmission, who should pay for it and how? That's the discrimination question. Then we get to the filed rate doctrine. The filed rate doctrine looks very simple. It says the utility shall charge the rate that is on file with the commission and only that rate. Well, that's pretty clear. Well, why is it there? It comes back to the railroad days because the railroads were granting secret discounts. So the filed rate doctrine is a rule of transparency, a rule of predictability. But it turns out it does more than that. The filed rate doctrine protects the jurisdiction of the regulatory commission, whether it's a state commission or whether it's a federal commission. If you don't like the rate that the commission has set, you can't go to court to have them change the rate. Well, wait a minute. We go to court all the time against commissions. I have. You go to court to test the legality of the commission's order. And what the court can do is find the commission's rate order unlawful, but the court cannot set the rate. The filed rate doctrine, which says only the rate set by the commission is the lawful rate, prevents the courts from setting any other kind of rate. By the way, there's a fascinating feature of the filed rate doctrine involving fraud. And there's a case where somebody challenged a Minnesota commission order on the grounds that the order had issued because of a bribe. And somebody once challenged an order of the commissioner of insurance in New Mexico on the grounds that the commissioner was bribed. And these plaintiffs asked the court to set a rate that would be appropriate in the absence of the bribe. And the Supreme Court of each state say, no way. A court could declare the rate void because it was obtained illegally, but a court cannot correct the rate. You have to go back to the commission. So fraud turns out to be, the filed rate doctrine turns out to be a defense against the charge of fraud when the plaintiffs are asking for refunds. The last doctrine to talk about is the Mobile Sierra Doctrine. It's purely under the Federal Power Act and the Natural Gas Act. It emanates from 1956, the same year that Dwight D. Eisenhower won his second election, the same year that Don Larson pitched the only World Series perfect game on the day I was born. The Mobile Sierra Doctrine, as I did say that, on the day I was born, the Mobile Sierra Doctrine says that for government to change the terms of a contract that buyers and sellers willingly entered into without duress, the government bears a high burden. They must show serious harm. It's what we call the rebuttable presumption. The rebuttable presumption is that contract rates reached by consenting adults under the Federal Power Act or the Gas Act are presumed to be just and reasonable, and one who attacks those contracts has to show serious harm to the public, not just to the buyer, but to the public. All right, lastly, Carl, then I'll turn it back to you. A chapter on the federal-state relationship. That's the one you want to study if you're taking the bar exam, because it will remind you of the federal powers vested in the Commerce Clause and limited by the 10th Amendment. And then we address the federal-state relationship in terms of the Supremacy Clause and the Dormant Commerce Clause. And I do have a subchapter, it says down here in minuscule terms, regulating within those constitutional limits 6 models of federal-state interaction. There are different ways over the years that the Congress has found to arrange the federal-state relationship. You know, what you've got with this federal-state panel that your neighbor president alluded to is an example of sort of extra-legal cooperation that could lead to some kind of legally binding cooperation. And I closed the book, Carl, with chapter 13, Jurisdiction's Future, where I remind us of something I said at the beginning of this talk, which is that the 2020s are very different from the 1780s and the 1930s. And we need to think, even in this time of political division in our country, we need to think about what we share. And that is the desire to have reliable, non-polluting, customer protective, shareholder protective utility service. And we need to find the best arrangement between the federal and the state levels to produce performance, because the job of regulation is not to protect regulation. The job of regulation is to produce performance. Carl.
Well, thank you, Scott. That was terrific. And what I particularly appreciate about the structure of the book is that it really addresses what I consider to be the 2 fundamental questions that state regulators have to address. And that is essentially, what is the role of the utility versus non-utility providers? And once that role is determined, how do you pay for it? Is it a competitive market? Is it a non-competitive market? So I really like that structure that you've adopted in the book. But as we see, the complexity of the world we live in is getting more complex, I guess, and we now have new focuses of society and things of that sort that were not traditional focuses of regulation. To the extent that you can, what does the traditional, and I'm very conscious of not going into anywhere, I don't know what's on the dockets at the FER, so let me know if I've stepped in it. What is sort of the traditional regulatory approach or law tell us about the role of the regulator going forward in terms of things like decarbonization and resilience? These are two factors. We always talked about just and reasonable rates, and we always talked about maintaining reliability. Resilience is a little bit of a different kind of animal than reliability is. So what are the big legal precedents that help us navigate to that future?
It's such a fascinating question. I'm glad that you brought me out of the, I guess I'll politely call it the muck of the book, to talk about something that actually works at a dinner table. Back in the 1970s, the National Association for the Advancement of Colored People, the NAACP, petitioned what was then the Federal Power Commission to issue a rule prohibiting racial discrimination in employment by utilities. And they said that the Federal Power Act and Natural Gas Act has the words public interest. And what could be more core to the public interest than prohibiting racial discrimination in employment? And the Commission, the Court of Appeals for the DC Circuit, and the United States Supreme Court, Justice Marshall, of course, recusing, all said that the Federal Power Commission lacked the power to do anything about racial discrimination, because the words public interest, when they appear in a statute whose purpose is economic regulation, have to be confined by that purpose. That the words public interest are not some signal to the regulator to do whatever they want to serve their vision for the public interest, but they're confined by the purpose of the statute. And so the lesson, now that's a federal interpretation of a federal court interpretation of a federal statute. But the legal lesson that comes from that from that case, NAACP versus Federal Power Commission. And Carl, I can send you the site to the case. It's easy enough to find, right, and really should be required reading. The lesson of the case is that we have to start with statutory intent, because this is a nation of laws. And if you think your statute is too narrow, go visit your legislature. So today's issues, privacy, affordability, yes, and racial justice, and economic justice, and environmental justice. These all overlap with utility regulation. We do things in regulation that affect people's lives, that affect their ability to afford power, that affect the environment. But in economic regulation, we normally don't have the power to do anything about it. And so then a political question arises. What is the role of regulation in the little field that we're in? And I'll just give you the answer that I gave to my students the other day. The role of regulation then, well, first of all, is to be creative. And if you have my book, my book of essays, Preside or Lead, the Attributes and Actions of Effective Regulators, I have a chapter on the NAACP case. And I say it was rightly decided. But I said that if you read it too literally, you leave things out. If you can relate racial issues to the performance of the utility, you've got something. Maybe it matters that the board of directors is all white males. Maybe it matters that the customer service centers speak only English in a neighborhood that's 1/3 Spanish, and it has Ethiopian speakers and Portuguese speakers and Vietnamese speakers. Maybe that affects performance. Maybe it's a problem that the board of directors doesn't look like the community that it serves. So maybe, therefore, if you can connect to performance, which is what the regulator's job is, these other issues of privacy, of economic justice, of racial justice, of environmental justice, then you're okay. But absent that, Carl, my last point on this is this. It's the regulator's job to sound the alarm to the legislature. If you're going to set rates that are the right rates because costs are high, but they're going to be unaffordable for the citizenry, you bring that to the legislature and you bring it with the loudest possible voice. That, I think, is appropriate for the economic regulator. But I personally think that we should leave the political issues, the big ones, the guns versus butter issues, to the political body, and the economic regulators should stay within their lane. Carl, that's the best answer I can give you. It's a great question.
Okay, well, I can see how to pursue both ends of the spectrum with that answer. So thank you, Professor, for that. And in particular, I mean, it's interesting that you talk about performance, because obviously resilience then fits into a broader context of regulation and the need for regulation, as does, you know, things like cybersecurity. And so that I think that you would say that there's a legitimate broadening of the scope of what a state and federal regulatory agency would look at as to what are just and reasonable treatments of different kinds of activities.
Exactly. I think that's very well put. What we're learning is that the decisions that we authorize as economic regulators have external effects. And we have to ask whether our statutes are accommodating solutions to those external effects, Carl.
Okay. I want to remind everybody that if you have questions, please put it into the Q&A. And I would recommend, I am quite familiar with the NAACP case, and often it's referred to as a rebuttal to ideas of expanding notions of just and reasonable. And again, I think one could argue, and I'm not going to do that here, that there are multiple steps that could be taken to connect the dots in terms of performance. And I thank you for that clarification. What do you see as the big regulatory law issues coming down the pike? We know that jurisdiction is an issue. Do you think that the Market Street issues of obsolescence are going to become increasingly more important over time?
Yes, as I said, the two prominent examples in obsolescence right now are decarbonization and the exchange of digital for analog meters. I find the state of the law on obsolescence and stranded investment unsatisfactory. I think that there are times when regulatory discretion becomes regulatory unpredictability. And if I'm wanting to attract investment to an industry, but I am unwilling as a regulator to make some kind of advanced promises about the recovery of the costs, I'm raising the uncertainty level and thereby raising the cost of capital. And I think that the regulatory community, and this includes legislatures, could do well to be more explicit about the responsibility of regulators to identify and allocate the risks of major capital expenditures with more explicitness upfront. I mean, we've had the situation with the Summer nuclear plant in South Carolina, the Kemper coal gasification plant in Mississippi, and the Vogtle nuclear plant in Georgia, where after the fact, of spending in excess of budget, we have controversy over who should pay for it. Now, there's certain controversies that are going to be inevitable, but others can be anticipated and planned for. And frankly, I find the status of the law and policy too loose for comfort in those areas. I'm not saying where the line should come down in terms of allocating the risk of bad luck to customers or shareholders. That's a call that the people who get paid more than I do and deserve it should make. But I think that we don't do well for investors or consumers by playing it so loose. So that's a big issue. As you said, I think that the federal-state relationship needs attention. But here's another one that I've alluded to, but let me be more explicit. That distinction between anti-competitive conduct and unearned advantage. You see, in law school, they have a course in antitrust, and lots of lawyers want to learn about antitrust. But antitrust deals only with anti-competitive conduct. It doesn't really ensure competition on the merits. And I think that regulatory statutes don't make that distinction well enough either. So quite often the utility gets an advantage in a new market and it says, we're not doing anything wrong. And they're not doing anything wrong. Look at me, I'm white and I'm male, okay? I went to college at a time where they were limiting the access of women and minorities and international students to Yale. And if you don't think that's an unearned advantage, it is. And here I sit, able to have this reputation and this language and the free time to write books because of that unearned advantage. And I realize it. In the electric industry, I don't think we're direct enough about that unearned advantage and what we should do about it. And the law hasn't kept up with it. So that's one reason why we're having these debates about the future of Facebook and the future of Amazon and the future of YouTube, because there isn't necessarily anti-competitive behavior, but there's a concern that maybe some companies are getting too big for society's capabilities to appreciate their values, and that we're going to have to do something up. And breaking up is a painful thing to do. I would prefer that we think ahead of time of what people can grow into, and then the expectations will be clear. So that's an area of the law that truly is relevant to regulation, especially when you see the pace at which mergers in telecommunications and electricity and gas have occurred, Carl.
So I'm going to shift gears just a little bit. One aspect of regulation is that while we try to be even-handed with respect to the utilities and customers, and the notion of justice or just prices is a balancing between those. Lots of regulatory activities have gone into what is now characterized as competition or competitive provision, and it seems to me, and I think that some of the background in the New York case that, with respect to independent providers of energy, has to do with this, that the role of the regulator in terms of customer protection in competitive services is perhaps not very well defined. And what can you tell us from your treatise in terms of that changing role, and whether or not many of the kinds of protections the customers need to seek are outside of regulation and may more reside in judicial determinations?
Or reside in customers learning how to look both ways before they cross the street. So I think there's a political question first, Carl, and that is, when do customers actually need protection, and when must they grow into practical, mature, alert, educated participants in a capitalist system? People often seek protections. I know this is going to have people running to their cell phones, but people often seek protections when they should have been more protective of themselves. And if you want to preserve the credibility of regulation, you should use it only as much as necessary to prevent actions that are inconsistent with the public interest. But to protect people from themselves, when they should know better should not be a function of regulation. Now, that's just, I shouldn't say just, that's my personal view about how to draw a boundary between customer self-responsibility and the role of government. But I think we should all have our own definitions of where that line is. Now, I was just stalling to try to answer the question. Here's the way I would try to answer it. It's a service by service issue. Look, if the only way to know whether your data is being sold for profit is to sweat through 10 single space pages of interminable prose that's written intentionally small with all capital letters so that nobody reads any of those letters, then there's a need to do something. Okay. And I don't think the need is to say, read before you sign, because I don't read this stuff and I'm supposed to be somebody who knows something about this business. So I think when there is conduct by sellers that is intended to cause customers to make mistakes, we have to do something about that. Does that involve regulators in a political function, making judgments about their fellow human beings? I'm realizing because of your question that it does. And I think that's appropriate. I think it's one thing for the regulator to set a rate because negotiating a single customer with the monopoly utility isn't going to work out so well. You're going to become somebody's lunch. But I think analyzing each and every step and saying, do we really need government in this role is the right thing to do. And reasonable people are going to disagree about this. But if you can keep the ideology out of it and just ask, should a reasonable person be able to make these decisions by themselves and suffer the consequences if they decide poorly? And does that lead us to a responsible, efficient economy? Then I think regulators should be prepared to do that. I sometimes see too much talk about customer protection and not enough talk about customer empowerment and customer education, Carl.
Well, I'm glad that you brought up the customer education piece, because it seems to me that often we have put customers in new roles without providing them with the information with which to protect themselves. And I have an article about my experience with the city of Santa Cruz school system, in which they were interested in obtaining contracts for solar for their schools, purchase power agreements. And they asked me to help them, which I did is on a voluntary basis. And they're probably one of the only contracts that Solar City has ever signed that had a tracking account in it to guarantee that the school systems wouldn't pay more for power. And that took somebody who'd been in the business 30 years, hiring an attorney who specialized in independent power production to help the school system to do that. So often the transactions costs of getting that information seem to me to be very high. And so therefore, does that lead to a different new kind of role for the regulator who is interested in promoting the transition to a new market structure?
I think that's such a powerful thought, Carl. In fact, if you think about it institutionally, why shouldn't every commission have at least one person or even a staff whose job it is to think about customer empowerment? A couple of years ago, I was doing some consulting for the New Zealand Energy Commission, and I was out doing my morning run, and I come upon a tall apartment building, and on there was this huge sign that says, "What's my number?" And it had a website. And you go to that website, and that's how you shop for electricity. You put in your address, and they will give you immediately a list of the people who are supplying electricity, it's retail electricity context, supplying it, and their current prices.
Right.
Now, how many states? My state of Maryland doesn't do that. And I don't believe most states do. But there was a lot of customer empowerment and a lot of emphasis on making popular the idea of knowing what you're doing when you buy electricity.
Right, right. Well, a lot of customers are making 20-year commitments at this point with minimal education with respect to how to look at those. Well, Scott, this has been terrific. I really appreciate your returning to do another talk with us, and I look forward to your next book, and yet another opportunity for us to talk about your new book. And again, I want to encourage everybody to look into taking Scott's course, which begins in January, and to encourage your staff to take Scott's course. I think that you can tell from the snippets that we've had today that it's going to be very interesting, and it will help them and help you as commissioners, as regulators, come up with better analysis, better decisions, and hopefully better service to the community that we serve. So Scott, thank you very much. I appreciate your time, and I appreciate everybody else's time. And I look forward to seeing you all in Kentucky. Please stop by the NRRI desk, pick up some of our recent papers. We've put out a lot of papers recently. I'd love to talk to you about what's going on in your state and how NRRI can help you with the issues that are in front of you. With that, see you all in Louisville this weekend. Bye.
Thank you.